Hello everyone and welcome back. In this video I'm going to talk to you about whether you can use the guardianship process, or for that matter even the Marchman Act process, to stop a Baker Act. And so this issue came about when a family called us. Their loved one had been Baker Acted, and they said to us, well, I think what we'd like to do is we'd like to file for a guardianship to stop the Baker Act. Their adult son had been Baker Acted, and the facility was telling them that they're going to file a placement petition, meaning they're going to go to court and get a court order to keep their son anywhere between 0 and the next 6 months. And as you know, I am a proponent of fighting to get your loved one out as soon as you possibly can, and not waiting, because once the court enters a placement order, getting them out can be challenging, and judges have hundreds of cases on their docket, and they don't want to go back and look at your case, and when it was my family member, my case, because they have loads of other cases. If there's been a hearing, there's been a hearing. Sorry, too bad if you don't think you got a fair hearing, you got a hearing. But I understand the frustration. And so the family said, well, we're going to file for a guardianship. So I think there's a couple of issues here. Number one, the state's right to detain your loved one under the Baker Act is absolute. And just to refresh your recollection, the Baker Act is a statute that allows the state of Florida to take custody of somebody. So if your loved one has been Baker Acted, they are now a ward of the state of Florida. Even though the Baker Act facility may be private in nature, they are a licensed agent of the state's mental health system, and they can lock up and lock down your loved one. They can also forcibly medicate them, and they can also file to keep them for a significant period of time, anywhere between 0 and the next 6 months. And so you cannot use the guardianship or even the Marchman Act process to stop the state of Florida from not only detaining your loved one, but moving forward with a placement petition. And even if you have a healthcare proxy and or a power of attorney, which I personally I'm not a big fan of when it comes to substance use and mental health issues, even if you have one, the state's right to take your loved one away from you and lock them up trumps just about everything. Now, does that mean we don't ever file for guardianship or a Marchman Act when someone's Baker Acted? No. Of course we file those cases. But we file them not because we're trying to stop the Baker Act necessarily, but because we're trying to get that individual some help. And remember, the Baker Act is not a treatment statute. It's not designed to treat anything. The mandate is to assess, stabilize, and release. Now, does that happen? I mean, based on the 100 or so cases I file every year to get people out of the Baker Act, arguably it doesn't happen as often as it should do. So you can't use guardianship and Marchman Act to stop the Baker Act process. What you can do is you can use guardianship and Marchman Act and a combination of both to get your loved one into treatment. Now, obviously, if they have been Baker Acted, we want to let the court know, the Baker Act court, hold on a second, Your Honor, we're about to file for a guardianship. We're about to file a Marchman Act. And so the court knows what's going on here. Now, hopefully the idea is that we are letting the court know that whatever issue is going on, we're going to address separately in another court, and we're going to get this person help. And we're basically saying to the court, Your Honor, we appreciate the fact the state stepped in here. Thank you very much. We have it from here. Please move the state out of the way here, because the family is the best situated to take care of this person and make decisions for them. And we're going into court, into guardianship court and or Marchman Act court. Now, is the court free to ignore us? In theory, the court is. Is it likely the court will pay attention to us? Yeah, I think it's likely the court will pay attention. If the court recognizes that there's a problem here, and there's a less restrictive alternative to locking somebody up, either in a local facility or a state mental hospital, then typically the court will work with us. But we're using the Guardianship and Marchman Act to intervene in the Baker Act case. But if there's already a court order in place, while you can still file these things, Guardianship and Marchman Act, it's really difficult to get the state out of the way, because the court's already reviewed this thing. And so again, it really goes back to getting, really taking action as quickly as you possibly can to get somebody out of the Baker Act. Now, if they don't meet guardianship criteria, in other words, if we don't have enough evidence to establish a guardianship or enough evidence to establish a Marchman Act, I'm not going to file these cases. As a lawyer, as a 31-year member of the Florida bar, I have to file my cases in good faith. I can't just file them knowing I can't prove these cases just to stop the Baker Act. Number one, that would be a bad faith filing, and I'll speak for myself here, not the rest of the Florida bar, but I don't file in bad faith. I file when I have evidence, and not only can I prove my case, but I have a good faith basis for believing I can actually win it, right? Otherwise, what's the point of you paying me money if I don't think I can win your case? I'm not taking your money if I don't think I can win it. And I'm going to tell you, and my team's going to tell you, this is a loser. I think your chances of winning are slim. And, look, you know me from looking at any of my videos. I'm not here to, for lack of a better word, to BS you. I'm going to tell you the truth. Always, always. At the risk of losing business, I'm going to tell you the truth. And my team is going to tell you the truth. And so if we don't have enough evidence, we're not going to file a guardianship or a Marchman Act. Does that mean I can't help you? No. You could hire us to represent your loved one as opposed to you, and we can represent that individual and move the court to order them to be released. So there's a number of ways to skin the cat here, but Guardianship and Marchman Act is not a way to stop a Baker Act. Okay, it's a way to get somebody help. And if they've been Baker Acted, then that might be evidence that they actually need help. So I hope I haven't confused you, but understand the state's right, the state's ability to either lock you up in the criminal justice system or lock you up in the mental health system is absolute. The state's power trumps everything. And so understand that. Which is why, I tell clients, I share with them, look, I was a prosecutor for many years. I did defense work for many years. You have to understand how the Marchman Act, the Guardianship, the Baker Act, and the criminal justice system can all interact together, sometimes to help the person, but you've got to know how to sort of navigate your way through the maze of laws and courts and all that other fun stuff. So I hope that helps. I appreciate the question that was asked of us, and I would love a thumbs up. Please subscribe to the channel, and I'll see you in the next video. Bye-bye.